So now let's talk about how to IRAC using cases and analogical reasoning. Now, in just a minute, I'm going to ask you to pause the video and reread the case of Cohen versus Petty. That's the negligence case that we read and discussed during orientation week, the one about the man who fainted while he was driving and injured his passengers. So while this video is paused, please reread that case and go over whatever notes you had for that case. And then also read this fact pattern that's up on the screen. And after you've done that, then come back to this video. Okay, so go ahead and pause this video now. Okay, now that we've refamiliarized ourselves with Cohen versus Petty, let's see how we might use that case to help predict the outcome of another case. And let's also see how we can use the IRAC form to write out our analysis. So in this fact pattern, the defendant, a man by the name of Matt Keegan, he was driving his taxi cab. He's a cab driver. He was driving his cab in Washington, D.C. when he suddenly fell asleep and crashed into a tree. Now, unfortunately, his passenger was injured in the crash. And it turns out that Matt Keegan, the cab driver, he suffers from narcolepsy. And he's been able to control his narcolepsy with medication for the past several years. And in fact, his last narcoleptic episode was more than 3 years ago. But again, unfortunately, it did happen again. He had another narcoleptic episode, and he crashed into the tree and injured the plaintiff. He's overall in excellent health, and he has a valid driver's license, and he's never fallen asleep before while driving. So the question is the defendant cab driver, Matt Keegan, is he liable for Amy Marino, the passenger's injuries under a theory of negligence? So just as we did when we were IRACing with statutes, let's start with our issue. Under Washington, D.C. law, is the defendant Matt Keegan, is he liable for plaintiff Amy Marino's injuries under a theory of negligence when certain facts are true? Okay? When certain facts are true. We haven't done the analysis yet, so we don't know yet what facts are legally relevant. So we just say when, ... just to remind us that we'll have to come back and finish our issue with the relevant facts. And then when we're IRACing after the issue, the next step is to identify the rule. And here the rule comes from a case. It comes from Cohen versus Petty. And the rule from that case is a driver who is suddenly stricken by an illness that renders it impossible for him to control the car, and which he had no reason to anticipate would occur while driving, is not chargeable with negligence. That rule just comes from Cohen versus Petty. So far, IRACing with cases is pretty much the same as IRACing with statutes. We start with an issue question or an issue statement, which we'll fill in with the relevant law and the relevant facts once we figure out what they are, and we state the applicable rule. So the only difference so far is that the rule comes from a case instead of a statute. Otherwise, it's pretty much the same thing as IRACing with statutes. But here's where it starts to get different. Before we can continue to the analysis part of IRAC, when we're IRACing with cases, we also need to do something else. We need to briefly summarize the case that the rule came from. Okay? We need to identify the holding. The holding, that's the court's conclusion on the issue. And we have to identify the relevant facts of the case. Right? These are the specific facts that led the court to its holding. And we need to identify the court's reasoning. The court's reasoning. Why the court thought that these specific facts should lead to its holding. Okay, so we need to identify three things from Cohen versus Petty: the holding, the facts, and the reasoning. So let's do that now. The holding in Cohen versus Petty, remember, was that the defendant was not negligent. It's not chargeable with negligence. That was the conclusion that the court reached in Cohen versus Petty. The facts in that case, The relevant facts were that the defendant had never fainted before, and he was generally in good health. Now keep in mind that when we're identifying the facts of the previous case, we're looking for the relevant facts. There were other facts in the case too, right? The fact that he's a man, that he was married to someone named Tree. Okay, but those facts had nothing to do with the court's conclusion, to the court's holding that the defendant was not negligent. So we just care about the legally relevant facts from our case authority. And then finally, the reasoning from Cohen versus Petty. And the court's reasoning was that, well, the defendant didn't know that he might become ill while driving. He didn't know, and he had no reason to think. Didn't know, and he had no reason to think that he might become ill while driving. Right? So that's the reason that the court felt that these facts should lead to this conclusion, right? He had no reason to think he might become ill, so it wouldn't be fair to say that he should be negligent, to hold him responsible for the injuries that occurred. Okay, now that we've done this, now that we've mini-briefed the case authority that the rule came from, now we can proceed with our analysis. And we do that by identifying how each side might compare or distinguish our case from the authority, from Cohen versus Petty. So let's do that now. Okay, so let's start with what what Keegan might point out. Keegan was our defendant. So Keegan will probably try to argue that that his case is quite similar to Cohen versus Petty, right? It's similar. It's analogous to Cohen versus Petty. After all, just like in Cohen versus Petty, Keegan is in good health, excellent health, in fact, right? He's in good health, and he's never fallen asleep before. At least while driving. I guess everyone falls asleep sometimes, but he's never fallen asleep before while he was driving. Now again here, we're only looking for the relevant similarities. There are other similarities too. They're both men, for example. Okay, but that has nothing to do with why Keegan would argue that the cases are similar. So we're just looking for relevant similarities. Okay, so Keegan will try to argue that our case is similar to Cohen versus Petty. Now, the plaintiff, Amy Marino may argue that the cases are actually distinguishable. Now, how would she argue that they're distinguishable? Well, for one thing, Matt Keegan had a history of narcolepsy. He had a history of narcolepsy, and that's different from Cohen versus Petty, because in Cohen versus Petty, he had never fainted before. He was in good health, and he didn't have any history of just fainting behind the wheel or anywhere else, for that matter. Okay, so again, we're only looking for the relevant similarities or differences. Okay, so there are other differences too. In Cohen versus Petty, the car wasn't a taxi cab. Okay, but that doesn't seem to be relevant to why the cases are different. It doesn't seem relevant to why Marino would argue that the outcome should be different here. Okay, so the point of identifying these similarities and differences is to try to analogize to the reasoning of the case authority and predict whether the outcome here will be the same or will be different. So Matt Keegan by arguing that that his case is similar to Cohen versus Petty. He's going to try to argue that, well, if the court from Cohen versus Petty were to apply that same reasoning here to these facts, it would probably reach the same outcome and find that he's not negligent. On the other hand, Marino would try to argue that, no, the cases are distinguishable. If you try to apply that same reasoning, you would actually find that Keegan should be found negligent because here he had a history of narcolepsy. So which of these arguments do we think is more persuasive? Well, like Cohen versus Petty, he's never passed out before and he's in good health, right? Now, it's true here that that Keegan has a history of narcolepsy. So arguably he should have known that this could have happened and it's different. But Keegan can respond to this. Keegan can respond to this by saying, well, his narcolepsy has been controlled by medication, right? In fact, his last narcoleptic episode was over 3 years ago. Okay, so he can effectively negate the difference of there being a history of narcolepsy here. He can say, well, sure, yeah, there's a history of narcolepsy. But if you apply the reasoning, and the reasoning was in Cohen versus Petty again, that he had no reason to think he might become ill while driving. So even though there was a history of narcolepsy, because the narcolepsy had been controlled and the last time he had an episode was 3 years ago, he again here had no reason to think that he might become ill while driving. That's why we had to identify the relevant the holding, the facts, and the reasoning from the case authorities so that we could apply it to our situation here. So now we can reach some conclusion about whether we think the outcome here will be the same as the outcome in Cohen versus Petty or will be different. And if we think that, well, Keegan has a good point. His narcolepsy was controlled, and so even though he had a history of narcolepsy, he really had no reason to think that he might become ill while driving, that he would fall asleep. And so based on that, we may reach a conclusion that just like in Cohen versus Petty, the defendant here, Keegan, is not chargeable with negligence. That might be our prediction, our conclusion. Not chargeable with negligence, just like in the analogous case of Cohen versus Petty. So now that we've gone through our analysis, we can actually go back and fill in the relevant facts in our issue question. So let's do that now. So let's come back up here and let's finish our issue question. Under Washington, D.C. law, is defendant Matt Keegan liable for plaintiff Amy Marino's injuries under a theory of negligence when what facts are relevant? Okay, well, it was relevant that he, it's certainly relevant that he fell asleep while he was driving and crashed into a tree. And as he pointed out, as Keegan pointed out, he, let's see, what does it say? He's in excellent health, has a valid commercial driver's license, never before fallen asleep while driving. We pointed that one out. Okay. But then Amy Marino pointed out that he has a history of narcolepsy. And Keegan responded to that by saying that his last episode was more than 3 years ago, and it's been under control for several years thanks to medication. So these are some of the relevant facts that were coming up in our analysis, and so we can now plug those into our issue question. So let's say, is he liable under a theory of negligence when he suddenly lost control of his car and crashed into a tree during a narcoleptic episode, but he had successfully controlled his narcolepsy with medication for the past several years, and his last episode was over 3 years ago? Okay, so now we can finish up our issue question and give the reader some context about our situation by including some of the relevant facts that were important to our analysis.